Assalamualaikum warahmatullahi wabarakatuh dan selamat sejahtera. Selamat datang ke Symposium Antarabangsa Islam, Tamadun dan Sains kali ke-8. Welcome to the 6th International Symposium on Islam, Civilization and Science. Dai hakkai isurame bombe kangago kokusai symposiume yokoso. Now we come to the next session. It's about the keynote address session. We have three distinguished professors for this session. Now I invite all of the speakers in the keynote address session. First one is Professor Dato Noor Aziah Muhammad Awal, followed by Professor Dr. Yasushi Kosugi, and the last one is Professor Dato Dr. Muhammad Yusuf Haji Osman. Please welcome to the stage.
Prof Inabab from Kyoto University, and Professor Dato Yusuf Osman, Professor Kashugi, officials from Kyoto University, and also University Kebangsaan Malaysia, and participants of the conference. Alhamdulillah, we are here to discuss the various papers, and my topic today, because I know there's three of us and we have a limited time, I'm going to discuss about Islamic family laws in Malaysia and overview and current issues, because this is my area which I've researched and studied for a very long time, and I think I will focus on areas of interest which is being discussed currently. But of course, in relation to Islamic civilization would families are basis of civilization. You need to have family values, families. Structure must be in conformity with Islamic hukum and hukum syara, and therefore as far as Islamic law is concerned, we must make sure that the Islamic law is being enforced in order for us to understand and to build a better nation. Now, I think this is very introductory to a lot of our friends from Kyoto, basically because Malaysia is a country with a federal constitution with 14 states, including the federal territories. We have Islamic family law comes within the jurisdiction of the state. You have to understand we have a federal parliament, we also have state legislature, they are all elected, and any matters which fall, Islamic family laws comes under Islamic jurisdiction of the state, and all laws pertaining to Islamic family laws are passed in state legislature and is enforced in the Sharia court in the states. Matters which the Sharia court has jurisdiction, the civil high court, which is a common law based court, has no jurisdiction to interfere. And we have a few grey area. We call it grey area because it's in the middle. It could be a civil court jurisdiction. It's also a Sharia court jurisdiction. And some of these grey areas, namely the most famous one is the Section 51 of the Law Reform Marriage and Divorce Act 1976 in relation to conversion of one party of a non-Muslim marriage to Islam, and converting the Muslim converted party then convert their younger children as well to Islam, and there will be custody disputes. And the issue now is still not being decided, because where should they go? Should they go to the civil common law based high court, or should they go to the Sharia court? And we have issues of probate administration as far as Muslims are concerned. If a Muslim dies, Muslim must obtain letter of administration from the High Court in order to administer the estates, whereas in relation to Muslims, their estates are being divided in accordance to the Fara'id law of Hukum Shara. But the Sharia court is only a rubber stamping, only does a rubber stamping job, where the Faraid division actually has been done by lawyers, sent to the Sharia court, stamped it, agreed upon it, then sent back to either the High Court or the land offices, where the smaller states state jurisdictions are being performed, and therefore estates are being divided in accordance to the letter of Faraid from the Sharia court. Now, also with that, Malaysian Islamic family law has faced certain challenges. Of course, in Malaysia, we have signed and ratified 2 international conventions relating to family and children. We have signed the Convention on Elimination of Discrimination Against Women and Convention on Right of the Child, and this was done in 1995. And these 2 conventions have some effects on family laws in Malaysia in general and to Muslims families in particular. Then I would like to look into the historical. This paper is going to look into the historical development of Islamic family law very briefly. Family and international, Malaysian and international convention that related to family matters, and also conflicts of jurisdiction. And I look into special features of the family law in Malaysia, and also highlight some of the most current issues. And the 2 current issues that I will look at would be child marriage, and also the issue of illegitimate children that has been discussed quite recently. Now, as far as historical developments are concerned, Malaysia, I've already talked about the existence of the 2 legal systems, the family law, Islamic family law legal system, and also for non-Muslim, and these are governed by the Law Reform Marriage and Divorce Act 1976, which is Act 64. And other than that, all matters, and as far as non-Muslims are concerned, all matters relating to marriage, divorce, custody, adoption, legitimacy, maintenance shall be heard in the High Court of Malaya, a civil court which is based on a common law system. Appeal of the High Court decision goes to the Court of Appeal and the Federal Court. For Muslims in the 13 states plus federal territories, we have family law enactments, each one for each state, and we have 3 Sharia court hierarchies in each state. So it's quite unique. In Malaysia, we have 14 states, including federal territory. We have 14 Sharia courts with 3-tier hierarchy, and there is no federal appeal. So each state is actually very unique, the family or Islamic family law systems. This is the 2 courts which I have explained. This is the Sharia court. We have the subordinate court, the Sharia High Court, and then the Sharia Appeal Board. This is the common law-based court. We start from the magistrate session, but family matters are heard in the High Court, Court of Appeal, and appeal to the Federal Court. Islamic statutes we have passed, apart from the amendment to the Constitution in 1983. What happened is that prior to 1983, all matters of family matters are heard in the Qadi court, the Sharia court, and then appeal can be made to the High Court, and or some matters could also go to the Civil High Court. Then in 1988, we passed an amendment to the Constitution. This, I think the date here is, this is for Islamic enactments, but the Constitution was amended in 1988, whereby all matters within the Sharia court jurisdiction, Civil High Court cannot take cannot interfere with those decisions. And that's the reason why I mentioned right from the beginning, there are some gray areas whereby there are also matters which the High Court can still have jurisdiction. Now, then the main aim of then we pass all this Islamic family, Islamic law, the Islamic law that we passed in the states when since 1983 are the Islamic Administration of Islamic Law Enactment, Islamic Law of Evidence, Islamic Civil Procedure, Islamic Criminal Procedures, Islamic Criminal Law, and also Islamic Family Laws. Then with all that, I also need to mention that all these statutes in 2003 it was amended and was passed through all the state legislature except Islamic criminal law. Islamic criminal law is still in the state, is still in its old concept, has not been amended because it did not get the approval of the councils of kings, Majlis Raja-Raja. In Malaysia, that's the other issue, that a lot of things could be discussed at the Majlis Raja-Raja because kings are actually oversees the administration of Islamic law in Malaysia. So each king of each state, we have 7 kings from 9 kings from all the states, and these kings are actually responsible for the Islamic matters in his own states. For states which do not have kings, like Malacca, Pulau Pinang, and the Federal Territory, it is the Yang di-Pertuan Agong who is responsible for matters of Islamic matters. Then Malaysia and its international convention, I've already mentioned CEDAW and CRC. We have signed CEDAW, and CEDAW we have reservation of Article 5A, B, 7B, 9.2, 16.1A, C, F, G, and 16.2. And then we also mentioned that Article 11 is actually mentioned on prohibition of discrimination on the basis of equality between men and women only. And then in 1998, we removed reservation from Article 2F, 9.1, 16B, 16D, 16E, and 16F. But we still have reservation of 16.2. But in actual fact, when we withdraw that, actually 16B has some problems because it's conflict with our faraid matters. Because that particular section actually said in relation to a state's distribution, it must be of equal distribution. And we probably have overlooked that, and we actually withdraw the reservation. But as far as Muslims are concerned, we are still bound by the faraid system. Then as to date, we still have this reservation, and this reservation, according to the Wisma Putra, we have made this reservation because it conflicts either with our constitution or the Sharia or Hukum Syara. At least Malaysia, when we signed this convention, we make a point that some of these conventions actually conflicted with the Hukum Syara itself. Now, I'm not going to discuss this too long. CRC, as far as the Convention on the Right of Children, we signed this in 1995. When we first signed, we had 12 reservations. Again, most of the reservation is because it conflicted with our constitution or Hukum Syara. And then in July 2010, we removed reservation of Article 1 on definition of child, Article 13, freedom of expression, and freedom of movement. But we still reserve Article 14, which is right to conversion, right to religion and conscience as far as children are concerned. We still reserve in terms of torture. We still reserve article on free and compulsory primary education. We still reserve on issue of identity and nationality as far as Malaysia is concerned. Now, we passed Child Act to conform or to actually implement CRC, and Child Act in itself is a general application applying to Muslim and non-Muslim children, and it goes to the court for children in the common law-based civil high court. It does not go to the Sharia court. And there are cases whereby the Sharia court would have sentenced a 14-year-old for zina or fornication, and a 14-year-old cannot be sent to prison according to the Child Act. Those are some of the conflicts that we have. And when Dr. Datin Paduka Jawiah and myself and some of our friends from Hadari, we do prison visits, and from time to time, we will meet these children in prison, and I'm also the counsel for the protection of children of Malaysia, and I would report to the ministry that, look, you have a child in prison, you're not supposed to be there. And when we look at it, and it is from the Sharia court jurisdiction, and the Sharia court do not have a prison on its own. We use the common prisons, and these are some of the issues that are conflicted with the jurisdiction. Now, does international convention form part of Malaysian law? This is a discussion that has been going on in the civil common law high court, whether these are part of our law, and if it does then some of the decisions that we've made may conflicted with the conventions, and those decisions may also conflicted with Hukum Syara. Now, I'm just going to go straight to conflicts of jurisdiction between civil and Sharia matters in relation to family. One of the most controversial sections is the issue of conversion of children from non-Muslim marriage to Islam by converted party, by converted parent. They were from non-Muslim marriage, they were Hindus, they were Buddhists. They've been married from between 3 to 10 years, some are 20 years. Then one of the parties to the marriage converted to Islam, then converted their younger children, some as young as 1 year old to 3 years old. And then usually abduct the children, take them into their custody, and there will be a custody tussle in the High Court, the Common Law High Court, and also in the Sharia Court. And then we have issue of probate administration, which I've explained. Child marriage is a very recent issue, something that has been cropping up here and there, which I explain later. And again, the other one is status of illegitimate children, and also in terms of conflicts of jurisdiction, we have issues of same-sex and domestic violence matters, domestic violence cases, because now the Domestic Violence Act has been taken to Parliament, and one of the most controversial issues was the demand from cohabitants, people who do not get married. They wanted the act to be applied to them. And these are of our concern, because in Malaysia, as far as we are concerned, Domestic Violence Act apply to married couples only, within that proceeding. So if you're not married, you're living together, you've been abused by your partners, then you will have to go under the penal code. We have certain provisions there, and it is of general application. But a Domestic Violence Act is also of general application. And the issue of being married is one of the issues which is quite important in Malaysia at the moment. So what the last I heard was that the ministry decided that no, it is only applicable to married couples. Non-married couple will have to rely on the penal code of Malaysia. And the same-sex issues, of course, Islam do not recognize same-sex. At the moment, Malaysia do not recognize same-sex marriages or same-sex union. Of course, all the parts of the world have passed this law, and the issue is whether can a Muslim contract a same-sex marriage or same-sex union under the civil law, under the common law-based law. Which has not been passed, but the issue is, can they actually contract the marriage? I'll give you an example. In New Zealand, such marriages is legal. They have a law, same-sex marriage, which has been passed in 2013. Let's say two Malaysians went off to New Zealand, stay there for about 10 years, get married under that statute, then came back to Malaysia. Do we recognize such marriages under the recognition of foreign marriages? They are both Muslims, and as far as New Zealand law is concerned, that marriage is valid and legal, and whether we in Malaysia would recognize this as such. And these are the internal, external conflicts of law issues which must be dealt with under our system. Now, special features of the Islamic family law, as far as we're concerned, since 1982 onwards, since we passed all the statutes in all the 14 states, what we have done was to codify Islamic family laws in Malaysia. That is a special, unique features of the Islamic family laws. What happened is that prior to 1982, all our Islamic family laws is based on Hukum Syara, which we extracted from the Al-Quran and the Book of Hadith. So it's basically all our Qadhi, when they're making decision, they actually have to refer to all the kitab, not through statutes as such. So we have 13 states at that time, and decision could differ from one state to another. Of course, we know the rules of the khilaf between the mazhabs, and also when looking at certain authority, the Sharia court judge may make certain decision differently. What happened prior to 1982, the government set up a technical committee set up and then drafted the first Islamic family law enactments for Federal Territory of Kuala Lumpur, and then take it to the Parliament. But in actual fact, Kedah was the first state to pass the Islamic family law in 1982. Because the Federal Territory takes such a long time to take it to Parliament. So Kedah has passed it, but based on the same kind of models that the Wilayah Persekutuan have. So what happened then, after that, all the other states follow suit, and we all, in all the 14 states, have our own Islamic family law. And it has the same features. It has issues of prohibited degrees of marriage, capacity to marriage, provisions of divorce, of maintenance, of distributions of matrimonial property, and also the do's and don'ts within the family matters. It being codified, it been written. So under Malaysian Constitution, in actual fact, Islamic law is considered an unwritten law in the Constitution. But when we passed the statutes in 1982 onwards, it has become a written law as such. So a lot of states has already have Islamic law in a written form. But in order to implement those sections, you still have to refer to the Hukum Syara and also the Kitab of Hadith and so on and so forth. So, but it makes the decision of the court more universal in forms in relation to the four mazhabs, and also it unified the Islamic family law in Malaysia. Now, when we codify, of course, that's the unification of Islamic law, and also there's the federal Jabatan JKSM. This is the Department of Islamic Judiciary of Malaysia. They have passed, they have then talked to all the states. See, when these states are all independent as far as Islamic law is concerned. So talk to the state, and we pass a regulation or directive where we offer the states to accept unification, and also whereby the law from one state is also can be enforced in all the other states. Prior to that, if a Sharia court in Selangor, in this state, made a decision asking or requesting a husband to pay maintenance to his wife, and if the husband moved to Negeri Sembilan just next door, that court order cannot be enforced. Now, with the unification process, what we have done that all these the 7 states that has accepted the unification and applicability of enforcement orders, these orders from Sharia Court of State A can be enforced and applied in State B. But the rest of the other states that did not accept those unification and applicability enforcement orders, their decision cannot be enforced in the states which do not sign those agreements, and it has to be made through agreement between those states. Then, and to me, Islamic law is unique in itself because we have the majority views, the minority views, you have the khilaf, and that makes the decision more flexible in many ways to suit. It is not a common law system. If you have studied common law, your decision is based on precedents. The highest court, federal court, for example, decision will bind the lower court's decision. In Sharia court system, no decision should bind the other court's decision because it is unique, and of course you have to look at it. Is more a very much civil law kind of application to the law rather than a common law based decision like we have in the common law system. So that what makes it so unique. And then also, as far as family laws is concerned, with the establishment of the 3-tier Sharia court, then the Department of Sharia Judiciary actually established the Suluh system. This is within the court system, but it actually expedites cases whereby when you made your application, certain cases will go to Suluh mediations, where it has been decided in that form, and then later taken to the court, and whereby it is only enforced and signed by the judge. So it is enforceable within that scope, but the decision has been made in a suluh session. Suluh session involved one suluh officer or mediator and representative or the parties concerned, husband and wife or their representative, to decide on the case, and then the decisions are recorded and then taken to the Sharia court judge and enforced. Which has expedited a lot of cases in the Sharia court. In 2002, 2003, there was a lot of publications in the newspaper saying that Sharia court cases was delayed for 8 years, 7 years. And at that time, I did a research for Selangor Negeri Sembilan and Wilayah Persekutuan on divorce cases in the Sharia court. And I found at that time there was no delay. 80% of the Sharia court cases were sorted out in 1 month. And basically because they went through the procedure. What happened was that because of that, a lot of criticism on the Sharia court then introduced the suluh system, which now has been implemented for many years and has given a very good impression of the Sharia court. In 2008, we introduced the family support system for the Sharia, for the Muslims, and this is where parties who had obtained a court order on maintenance would, if the husband refused to pay maintenance, under the Hukum Syara, it is the responsibility of the husband to pay maintenance of the children. And a lot of cases, the wife would be able to get an order from the Sharia court, please pay 500 a month. The husband will pay in the first month, the second month, the third month, he forgets about it. And he said, oh, my salary has been, did not come in this month on time, so I forgot to send you the 500. The fourth month, he totally forgotten. Then on the fifth month, the wife would go back to the court and say, look, my husband has not paid maintenance. And a lot of time also the husband just moved jurisdiction, go to a state which did not which did not form part of the unification, and say, I just refuse to pay maintenance. So what happened is that we set up the family support system, whereby the government gave actually 15 million to this family support, and this money we asked each state to open up their own family support account, and some of the federal money were put into the federal to the states fund, and therefore they shared this. So if the federal gave 100,000, the state also give 100,000. What we do with this money is that when a wife, after 4 months, the husband have not paid maintenance for the children, will go to the family support unit, showed them the court order, then the family support will give them the maintenance, while the family support unit go and find the husband and take him to court for contempt of court. So that's what we're doing now. And then of course, just very recently, I think about 2-3 days ago, the minister has announced that there will be an establishment as a special panel to empower the Sharia courts. These are some of the issue of Sharia court. I would call it a family court because the majority of cases that goes to the Sharia court are family matters. The criminal jurisdiction of Sharia courts are very limited, only on religious criminal offences. So that is the reason why I think this is a special features of the family court relation. Now, current issues, I would like to discuss the issues of status of legitimate children. Now, as far as Islam is concerned, I think it would be good to explain that under Islamic law, legitimacy of a child is based on legitimate birth, where child is conceived after parents have lawfully married. Sex before marriage is strictly prohibited, and of course upon birth the child is registered, being given a birth certificate. That birth certificate is governed by the Registration of Birth and Death 1957, a statute passed of general application passed in the federal parliament. So it applies to Muslim and non-Muslim. What happened is that, of course, as far as illegitimate children is concerned, nasab, the issue of nasab, the father of the child must be the father who actually had got the mother pregnant, but the sex must be done after the marriage has been solemnized. So that's one of the issue that needs to be clear. A lot of people are not clear in relation to the Islamic law of legitimacy. And then if the child is legitimate, the father's name will be inserted in the birth certificate as being the surname of the father. So in Malaysia, we don't use surname like in the Arab world or also in the West. I think in Japan also you have surnames. But what we have is binti, the daughter of or the son of the father, the legitimate father. If the child is illegitimate in Malaysia, there was a fatwa in 1998. It's a national fatwa, which actually states that in cases of an illegitimate child, the father's name shall be Abdullah, name of the good names of the few names of God. So it could be Abdullah, Abdurrahman. But in that particular fatwa, it was recommended that we use the name Abdullah. So the biological father could be Ali, but in the birth certificate, because the child is illegitimate, it would be Ahmad bin Abdullah instead of Ahmad bin Ali, Ahmad daughter or a son of Ali. Now, we have practiced that since 1998 and we have no problems until recently. A couple actually, this was the case, the couple actually went to court, to the High Court, and actually apply that the Department of Registration to change in his child birth certificate, the word Abdullah into his name, the biological father. The couple admitted that the child is illegitimate, born 5 months, 25 days, if I'm not mistaken. And then in the birth certificate, when the child was born, the father's name was Abdullah. But the father said, look, I would like this to be changed into my name, and he should be able to bear my name as the father of the child. Now, the High Court, when looking at this case, applied the Registration and Birth Act 1957. And of course, the court, when in making its decision, this is one of the second highest court in Malaysia, the Court of Appeal, decided that the father should be granted his application. So he was allowed, the court actually ordered the registration department to change the word Abdullah in the birth certificate of the child to the father's real name. Now, this has raised a couple of conflicts. What are the issues? This case has raised a number of issues which highlights in the conflicts of two legal systems and raised a number of issues. All matters relating to Muslims actually shall be brought before the Sharia court, to the Sharia court. And these are Muslim couples, and they wanted to change the birth certificate. But the problem is the Registration of Birth and Death Act is not enforceable in the Sharia court because it's a federal statute. Yeah? Now, secondly, under the Islamic family law, child born less than 6 Qamariah months is illegitimate and shall be registered as son or daughter of Abdullah. That's the fatwa. Biological father has no relationship to the child as far as Islamic law is concerned. Fornication and adultery is an Islamic criminal law offense and shall be punished in accordance to Islamic criminal laws in Malaysia. National fatwa has no legal effect on the Court of Appeal. That is true because fatwas are for states and only bind states legislature. And child has no right to know, as far as CRC is concerned, it is a child's right to know his or her identity and a right to a surname. Now, these are some of the conflicts that arises from this one particular case. The case now is being taken on appeal to the federal court, the highest court in Malaysia, and we await the decision of the federal court and see what that could be. As far as we are concerned, the legal fraternity are actually prohibited to discuss what is the outcome of the case because it will be sub judice because the case is still pending in the federal court. But however, these are some of the issues that need to be considered. And of course, this actually raised the conflicts of law in family matters as far as Malaysia is concerned. Now, my other area that which is quite recent to Malaysia as well, is the child marriage. As far as jurists are concerned, Muslim jurists, puberty is not a prerequisite for marriage to be valid. And under Islamic law, any child can be married off by their guardian, which is the wali, before they reach the age of puberty, if and when they are deemed to be physically ready and fit for marriage. Majority of jurists was of the opinion that such marriage cannot be consummated until both husband and wife have attained sufficient maturity or puberty. Jurists unanimously agree that children are only to be married off when it is in their best interest and not for the guardian's benefit. Now, issues of child marriage came about, I think, about in the last 5 years. And cases of child marriage, we have to understand what is a child marriage. There are definitions of child marriage which I think are being used by a lot of human rights group. Now, I consider it is a child marriage if the female is under 16, it could be 14, 13, but the male is 50, 45, above 40. That's a child marriage. Yeah, because the female is so young. Yeah, and there could be element of forced and early engagements right from. And this practice has been done in a lot of Muslim countries, not because of the Islamic law, but because of culture. It's been done in the Middle Eastern countries. It's been done in India, Pakistan, African countries. So it's a culture whereby the female are very young. Yeah. And also because a lot of child marriages was solemnized because of poverty. Families are poor and family needs to get their young girls out and married off so that they will not have to look after these children. And issue of child marriage, the other is that we have in Malaysia is where the both couple, male and female, are children. The female could be 15, the male could be 17. The female could be 16, the male could be 20. The age gap is so small that they still consider child marriage because the female is under 16. Now in Malaysia, under 16, having sex with an under 16 is statutory rape, right? And there are exceptions that unless they are lawfully married under custom and religion, under the penal code. Now, the issue, what has been brought up by the International Convention on Rights of Children, CRC actually would like to prohibit child marriages, stop it. Who is a child? A child is a person under 18. There's a lot of strong movement now to actually say that could we raise the age of marrying to 18 so that all marriages which is solemnized when the person is a child is void, null and void, which is very difficult to do because in Malaysia we have we have laws in relation to marriage. Now, as far as non-Muslims are concerned, non-Muslim marriage between female under 16 and male under 18 is null and void. And you do not have records of it because it was never registered. And if they do, they will be charged for rape. If a man have sex with a female, even though he married her off under customs, because the law will not recognize such marriages. And we have cases, I've just finished a research with UNICEF and on child marriage. The fund was from UNICEF. And there's a lot of such child marriages in the Indian community. And they got married in accordance to Hindu rites, but they do not register the marriage. They stay where they are until the girl comes of age, above 18. Then only they go to the registration office, have the marriage registered. And as far as non-Muslims are concerned, a child who is born, and they do not even register the child, we have a lot of cases of undocumented children because the marriage is not registered yet. So the moment the father and mother went off and registered the marriage at the registration office, under the Legitimacy Act 1971, that marriage legitimized a child who has been born prior to the marriage for non-Muslims. Yeah? So for non-Muslim is a non-issue of illegitimate children and also trying to recognize the status. So if the parent married 5 years later, that marriage will recognize the child who has been born 5 years before they got married. Then that will settle the issues and they could change all the surnames and whatnot. And now, A non-Muslim, if you are 18 to 21, if you want to get married, you require the permission of the father. If you're legitimate, and from the mother if you're illegitimate. For Muslim, if female is under 16, male is under 18, you must apply to the Sharia court and apply for permission from the Sharia court judge to marry, and it is the discretion of the court to allow such marriages. This is the issue that is now in Malaysia. They would like the Sharia court not to give permission for such marriages because it contravenes with CRC, a conventional right of the children. But they have to understand that in Malaysia, as far as Malaysia is concerned, a lot of the marriages that under 16 and under 18 for male and female respectively is because the couple or the girl is already pregnant, at least 2 months pregnant, or even 7 months pregnant. So in order, the marriage will not legitimize the child, because child must be conceived before marriage as far as Islamic law is concerned. But it actually will, shall I say, avoid all the embarrassments of the family. So in order to avoid the embarrassment, the couple got married. The child might be born much earlier. And this is the same issue that we have in the courts recently, because the couple, she was already pregnant, they got married, of course the child was born, it was given the same name of Abdullah, and then now, after being married for many years, they would like to change that surname Abdullah to his own real name, making him the legitimate father of the child. Of course, he is the biological father, but as far as Islamic law is concerned, he cannot be the legitimate father, because there is no relationship between illegitimate child and his father as far as Islam is concerned. So these, now I would like to conclude, but before I conclude, these two issues of illegitimate and child marriage are the two main issues of Malaysian societies. I think under Hadari we would like to move on and look at this. These are nation issues, national issues, and probably international issues when it comes to CRC and CEDAW as well. As far as CEDAW is concerned, because you're talking about rights of women to marry. She has a right to consent to her own marriage, to have sex before or after marriage to whichever man she likes. That's the human rights under CEDAW and CRC, and also for children. So even under CRC, you have rights to reproductive rights of children. Children have rights to have sex when and whenever they think is suitable to them, not necessarily after 18 or after 16 or after they got married. So these are some of the conflicts in relation to issues in Malaysia. I did not put in the other issue of the same-sex marriages because to be honest with you, I prepared this paper last night after coming back from our beautiful dinner, and I have to finish it off this morning so that I could present it. And these are some of my thoughts. The issues of same-sex marriage and cohabitants, people who are not married. There are a lot of Muslims now who actually live in and do not get married, and in relation, my concern are the children. And if the court actually decided that the biological father could be, and his name could be inserted in the birth certificate, then there is no difference between legitimate and illegitimate children, and that will disturb the families, the Islamic family law structure, and also Muslim families. Because nasab is the basis of the family, and it's very important because a right of a child under Islamic law is based on the legitimate nasab, and that's when he could actually ask for right to maintenance, rights to education from his or her father. So I conclude that Islamic family laws in Malaysia have undergone extensive changes to suit current circumstances without changing Hukum Syara. We have not changed Hukum Syara. Hukum Syara stay as it is. We look into it and apply it to the current circumstances. Law has the Islamic family laws has empowered women to go to Sharia courts and to apply for divorce and enforce her rights. Conflict between Sharia and civil court shall continue as we live in a pluralistic legal system, and our pluralistic legal system do not have a one main court of appeal. in some states, in Malaysia now, Sharia, we have Sharia court system. We have native court system in Sabah and Sarawak. We also have the civil, which is a common law based courts throughout Malaysia for everybody except Islamic family law matters. So with that, I think unless we we amend the constitution, unless we look again into certain issues, then probably these conflicts would be eliminated. But as it is, as we are now in the 21st century, the issues are becoming more complicated, and Malaysians should sit down and discuss how we could resolve all these issues. With that, I thank you for listening. Assalamualaikum warahmatullahi wabarakatuh.